A very good day. I am Vishwajeet Deshmukh, Multimedia Editor at JURIST, and today I shall be interviewing Professor Homer Pithawalla. Professor Homer Pithawalla is a practicing advocate of the Supreme Court of India, Bombay High Court, as well as the solicitor at Bombay High Court, Supreme Court of England and Wales, and Supreme Court of Hong Kong. He is the senior most professor of law at Government Law College, Mumbai, where he has been associated for the last 5 decades. He is also recognized as one of the top experts in the field of corporate law and competition law in India. Professor Pithawalla has previously lectured at Harvard Law School, uh, the law school at La Sorbonne in Paris, France, and University of Cambridge, along with International Bar Association and Institute for Chartered Accountants and Institute for Chartered Secretaries. We are great to have Professor Pithawalla here today.
Well, it's my pleasure.
Uh, Professor Pithawalla, you have had a very long career and you have taught at the oldest law school in India, the Government Law College, for over 5 decades. Witnessing this transition of legal education almost through half a century and seeing the law evolve to what it is today, has the transition of law in India as expected or in the same direction that you expected it to be?
Well, I think I can see two queries in your question. One is as regards the evolution of the law, and the second one is as regards evolution of legal studies. Now,
Yes,
let me tell
indeed.
you that when we were students, which was naturally more than 50 years ago, we were quite disappointed with three things. Number one was that we had professors who, I'm sorry to say, were not what we expected them to be. Number two, we were disturbed by instances of judicial corruption, especially in the lower courts. And thirdly, we resented the idea of delay in litigation. I mean, if you have given a loan to a friend in good faith, and if he doesn't pay you back and you get your money after 10 or 12 years, I mean, this is not really justice. And all of us thought that we are now law students. Very soon we'll be young lawyers. And as budding lawyers, definitely we will be able to change the scenario. It is in our hands, since we know where the drawbacks are, we will be able to make a change. But I'm sorry to say that 50 years have lapsed and we are still disappointed. As far as advances in the law are concerned, in the last 50 years, yes, there has been a lot of legislation. There has been a lot of statutes brought into effect. In my days, there was no competition law. There was no Right to Information Act, and so many other things. I think personally that we have the best laws in the world. And yet, what is the problem? Why are we facing so many difficulties? I think it is the implementation. What good is a law if the citizens do not follow it? And if the authorities do not care to implement it? So I think implementation and not the making of laws is the real problem. I can think of a couple of instances. I'm sure that you may be aware that spitting on the road attracts a fine under the law. I think it's 1,000 rupees for the first offense and double that amount for the second offense. And yet, believe me, in my whole life, I have not seen a single person being fined for that. People merrily spit at pleasure, and you see all that red color on the road. In fact, I remember that when the famous author Mark Twain was in Mumbai, people asked him, reporters asked him as to what was the most impressive thing he noticed when he landed. And his reply was, I was shocked to see the roads stained with blood. That's what he said. The second thing which many of my students I found were not even aware of was that the Bombay Prohibition Act is still in force. If you don't have a permit, it is illegal to buy liquor, it is illegal to drink, it is illegal to even store a bottle at home, it is illegal to transport it from the shop to your house. And yet, you can just walk into any liquor store and buy a bottle. So, rules are there, the law is there, but how far are they implemented? That's my question. In fact, when they are not allowed to sell people liquor without a permit, I have a permit, but I didn't show it to the shop and I insisted on a bill. I said, now let's see how this man is able to give me a bill when this man apparently does not have a permit. So the store owner said, no problem, we'll give you a bill for the wine or beer which I purchased. And he gave me a bill for exactly the same amount and I took it away. When I reached home, I found that the bill was made in the name of some Ashok Gupta with his permit number. So really, the store has a list of names and a list of permit numbers. It's very easy. Put anybody's name and his permit number, and you sell liquor to anybody you want. Now, this is as far as legislation and implementation is concerned. The plus point here is the role played by the judiciary, especially by the Supreme Court and various high courts. Judicial activism has ensured that the law is enforced, not only in its letter, but also in its spirit. And the best example we can think of is the fundamental right to life and personal liberty. Mind you, Article 21 of the Constitution only mentions these two phrases, life and personal liberty. But the interpretation put on this by the Supreme Court has expanded this right to an enormous extent. The Supreme Court has said that the right to life also means the right to a healthy life, the right to a healthy environment, the right to possess a passport, the right not to have your monuments damaged by the environment, the right not to be handcuffed unless absolutely necessary. And here I think we must remember the role played by a leading activist, Mr. M.C. Mehta. He filed dozens, literally dozens of public interest litigation on things like closing down the factories which were polluting the Taj Mahal, and the white stone had almost become gray or black. I've seen that myself. On closing down so many industries which polluted the river Ganges. When I went there, the holy river had water which was brown, dark brown, and no wonder. So therefore, the Supreme Court has not only entertained, but I would say it has also encouraged public interest litigation for the good of the people. And Mr. M.C. Mehta was such an active person trying to enforce fundamental rights that there was a time when there were so many cases that one day of the week, I think Friday, was reserved only for his cases in that particular court. Now, if you come down to legal education, I think there again, I feel a sense of disappointment. Nothing great has been done in the 50 years which have gone by. I would not talk of the national law schools because they have liberty. They are autonomous, they can do what they want. But take a place like our college, the oldest law school, not only in India, but in Asia. We have no liberty to choose what subjects to teach. We have no liberty to charge students what fees we would like to. And we have no liberty to pay professors emoluments which they deserve. And perhaps one reason for that is that our law school has three masters: the University of Mumbai, the Bar Council of India, and since we are a government college, the state government. So when you have three masters, you know what happens. When there are too many cooks, we all know what happens to the broth. The extent of my disappointment has been so acute. I remember that the 1940 Arbitration Act was prescribed for our students. It was obviously outdated, and later on we had the Arbitration Act 1996. 3 years, for 3 long years after the new act came into force, students had to be taught the old act. Questions in the examination were based on the old act. Fortunately for me, I did not teach that subject, but I would really find this very repulsive to teach some law which does not even exist. And the Mumbai University, of course, it has got a board of studies and whatnot. They had to be reminded 5 times that please make the necessary change. So therefore, the syllabus is quite outdated. For instance, competition law is an extremely important commercial law today. It's nowhere in the syllabus. The law relating to cooperative societies, where most of us stay today, that law is not there. And what makes me upset the most is that they have removed a subject called drafting, pleading, and professional ethics. Now, how good a lawyer would be without any knowledge of these three subjects? In fact, when I was asked to address a group of students and lawyers on professional ethics for lawyers, we had a good discussion. But one lawyer got up and said that if this is so important, why is it not taught formally in the law schools? And I said the first thing which occurred to me in my mind, I said maybe the subject is not taught because professional ethics does not exist. Now, this is something which I have always told my students. We are supposed to teach them every section of the Contract Act. But do we ever teach them how to draft a contract? Do we ever teach them what precautions are to be taken to protect your client? Well, I try to do that in the time at my disposal, but otherwise it is merely a theoretical knowledge of the subject. And when the student lands up in the courtroom, he just makes a fool of himself. In fact, I was once teaching voidable contracts to the students. And I said, look, this is the law, this is the theory as regards voidable contracts. But remember that when you become lawyers, no client is going to come to you and say, please close your book and give me the full list of voidable contracts. No. He will show you a contract and he will ask you whether it's valid, voidable, or void. And this kind of a practical thing we do not really teach. So, of course, as I said, try to give examples now and then. And sometimes these examples just get stuck into the head of the student. And I was very pleasantly surprised. This was last year. I was with some clients in my office. The phone rang, and the man on the other side said, I'm so and so. I was your student 15 years ago. Fortunately, I remembered him by name because he was a good student. And although I was sitting with clients, I said, anything urgent? I got the impression that this man was quite excited about something. So he said, yes, yes, I'll just take 2 minutes of your time. I want to tell you what happened today, just now. I said, what happened? He said, I was arguing a company law matter in the court, in the Bombay High Court. And out of the blue, the judge asked me a question. And really, I fumbled because I just could not think of an answer. Then he says, I suddenly remembered a hypothetical example given by you in the classroom. And when I gave it to the judge was pleased, and I got the order which I was asking for. So really, it is these little things which matter, and not whether you get 60% or 70%. Now, of course, it is possible to get 100% in online exams. So I think that more or less answers your question, Vishwajeet.
Yes, indeed, sir. It's truly so inspiring to hear names such as MC Mehta, who truly revolutionized environmental law in this country, and even the views expressed by you on legal education. Uh, Another unprecedented move which has happened is that the Forum of Education has now switched modes, and now mostly online classes and law lectures have been happening. So, would you like to enlighten us through what are the hurdles faced by the professors, as well as some hurdles faced by students from your personal experience?
Well, online is online. The personal touch is definitely lost. I mean, it's one thing talking to you right now. It's quite another if we were both 2 feet away in the law school. And I feel that the online lectures may have to go on for quite some time because of the pandemic, but they are no substitute for the personal interaction between the teacher and the taught for many reasons. One of the reasons is that you are totally dependent on your internet. And then because of the pandemic, many of our students have gone home where there are internet problems and electricity problems. If there's no electricity, there will be no internet. And therefore, it becomes rather annoying that a student is trying to make a point, or I'm trying to make a point, and suddenly the internet snaps. Also, many students, for various reasons, like to keep their videos off during classes. Now, this is not a very good thing as far as I'm concerned, because one does not like really to speak to the wall. And even in a place like Zoom, I think you can see about 12 people, or is it 16? I don't know, at a time on one page. So when there are close to 100 students, you have to go to the second page to see some more students. At what point of time you cannot see the students on the first page or on the third page. I personally enjoy watching the facial expressions of my students. That is the most natural thing. I also enjoy their spontaneous remarks on certain things which I have said. Now, most people keep their mics off for technical reasons, and naturally, I cannot see all that. In fact, after I have initiated a small debate in the classroom, I often find that there is a very heated debate between two of my students. I am out of the picture, and these two students are having a hot debate with, of course, supporters on both the sides, which is just not possible with the online class. But can I go a little further
Yes, sir,
and say
absolutely.
how disappointed I am with the online examinations? I have not been personally involved, but I have spoken, believe me, to dozens of my students. And each and every student has said that there is absolutely no trace of supervision when they are giving the exams. Now, some students may be in Mumbai, but others may be in Ahmedabad, some may be in Patna, some may be in Agra, Ranchi, wherever. And although the technical company which organized the examination had a session where the students were warned that you have to look directly at the screen, and if you look down more than 3 times, you'll be disqualified, etc. None of this was implemented. What I'm trying to say is that a student could take the online exam with all books open on his lap. He could even Google something which on his mobile, which would be the answer to the question. But I will go one step further. There is nothing to guarantee that the person who is sitting before the computer is the student himself. Now, what kind of an examination is this? If I have a brother who is 5 years elder and who is already a lawyer with 10 years of experience, he might as well be sitting here. Or my uncle, who is a judge, could be before the computer, and whatever he types in will be my marks. No wonder our students, when the exam was first introduced, our students in many subjects got 100 out of 100. Now, just tell me, is this ever possible in a normal exam? One student got 100 out of 100 in 3 out of the 4 subjects and 96 in the fourth. Now take a subject like the Indian Evidence Act, where she got 100 out of 100. Are we trying to say that there are students, and many students got 100 out of 100? Are we trying to say that these students are masters of the Indian Evidence Act and there is not one thing which they do not know? The funny part is that the students are very happy, their parents are very happy that we got 100 out of 100. But what happens when you send your CV to a foreign law school for admission to the LLM? They are going to laugh at the Mumbai University. Who gets 100 out of 100? Also, if you go for an interview to a potential law firm which you are going to join, and the partner interviews you, he knows very well, he was a student himself. He knows very well that getting even 60 or 65 out of 100 is a very rare thing. So therefore, this mode of online examinations, where there is nothing even to establish the identity of the person who is taking the exam, I think it's a big farce. I mean, I'm not sure if everybody agrees with you. The students may be happy because it's become very easy. It's an exam where you open the books, where you call your friends, nothing is recorded, you just have to type. It's a very sorry state of affairs.
Most certainly, sir. It's very concerning as a community itself of students and even professors, as established by you. Being a student who has been taught by you for the past 4 years, this is something which we have noticed is you do not take the attendance of students who flock to your class, and often your class overflows. On the other hand, you have always said that the students should regularly attend law classes. Don't you think there is some amount of contradiction in these terms?
No, I will explain. The two concepts are different, they don't contradict each other. I always believe that any student and every student who comes to my class should come for the knowledge which he hopes to get in the classroom. I would not like one single student in the class only because he has to put his hand up and say that he is present. And many students do that in other classes. What happens is that the student has forced himself into the class. He doesn't want to be there. He himself is distracted, and most likely he will distract the other students also. And I have had an argument, not an argument, but many arguments with the principals. You know, there have been various principals, unfortunately, and I have not counted, but I think I have worked under about 15 principals so far. And some of them have called me to the principal's room and said that, look, I find you have not been taking the attendance, and that's not a nice thing. And my reply was that, look, rather than waste 8 to 10 minutes calling out the numbers, some of which will be answered by proxies and not by the students themselves, is a waste of time. I would rather have some more discussions in the class during this period. And I remember once I told one of the principals that, look, if this is the door of the class and a student is here, why do you want to push him into the class like this? Would it not be better if the student is pulled towards the class and not pushed into the class. And any genuine student would come whether there is attendance or there is no attendance. Some students say, but that is for your class. What about the other classes? And we are really not benefiting much from those classes. Now, the student is right to a certain extent, but I always say that even if you feel, that's your subjective judgment, even if you feel that the professor is not so nice, not so good, not so informative. I mean, I know professors who come to class and just read out some notes which they have made at home. If somebody gets up and asks a question, the professor refuses to answer, saying that don't please disturb my trend of thinking or whatever it is, which is not the right thing. I admit I also don't know all the answers, but the more questions asked, I feel better. And there have been occasions where I have told the students, frankly, I don't know the answer. We'll discuss that tomorrow, and all of us look it up. So, therefore, I tell the students that even if you learn 10% of what is said in the class, even that is something where you benefit. I also tell students who come to my class to be punctual, come on time. A very simple reason for that. Maybe in the first 5 or 10 minutes of the class, I am explaining a concept, let's say of fraud or voidable contract. And the rest of the 1 hour will be devoted to that concept. So if you have missed the first 5 minutes, you're not likely to follow the next 1 hour. So I tell them to be punctual and I tell them to be regular. Regular because if you have missed yesterday's class, you may not really understand what is being talked today in the class. And going into the class, as I said, should be made voluntary. The student should be himself motivated to go into the class. I was visiting the law school at Georgetown University in America, and a student of mine was doing his LLM there, and he told me something interesting. For every subject, and we were talking of torts, the syllabus was covered independently by 3 professors. And all students were free to attend the class of any of these 3. My immediate reaction was that if this is so, and especially if this happens in our college, I am sure one class will be entirely full, whereas the other classes will go empty. But that student said, no, that does not happen here. All 3 classes are attended by approximately the same number of students. It is just that one student prefers the teaching methodology of one professor, whereas another student would prefer to go to another class. But that system obviously cannot work in India. In fact, if I may just tell you one more thing, which surprised me. There was this girl in Chicago doing her LLM from our college, and she was with the Northwest University. We knew her parents, and the parents were coming over. So on the telephone, we said, when do we meet? Why not fix a date when we can come and meet you and your parents? She said, sure, but I'm not sure whether I am taking my TOTS paper on Monday or on Wednesday. I said, what do you mean? You have a choice to take it on Monday or Wednesday? She said, yeah, absolutely. I have a choice. I said, well, that's very flexible and that's very nice. But I feel bad for your TOTS professor because then you would have to set two papers, one for Monday, one for Wednesday. She said, no, the same paper. I was shocked. She said that we kind of take an oath whereby the student who went in on Monday is not going to disclose the questions because the same question paper will be used on Wednesday. And I'm sure many other universities also would be following that. I shudder to think what would happen if we introduce that in India. I think only one boy would attend the first day, and then the question paper will be sold for $1,000 for the next day. I mean, this is unfortunate. The mindset of the student is very important. And I'm so sorry to say that I have seen so many law students cheating and copying in exams. Now, if a law student does that, I'm talking of regular exams. Now, of course, online is free for all. If a law student does that, what kind of a lawyer is he going to make? And I cannot mention names, but I had a boy from the hostel who was very upset and he came and said, look, I'm studying so hard for my exams. But most of the other boys, and the exams was only 1 week away, most of the other boys are preparing notes and chits and other ways to cheat at the exam. So this mindset, as I said, is most important.
Uh, That's very interesting to get perspectives from so many jurisdictions and so many different law schools, which perhaps one can only imagine going through, especially in India. Let's talk a little bit about your career. And you have had a very diverse career, not only as an educator, as a professor, but even you practiced. And we also know that you were involved in contract drafting of the contract legislation of the royal government of Bhutan. How was that experience for you? So, how being involved in the process of legislative drafting and making those laws for that country. Could you tell us about it? How did that go for you?
Well, that was my first experience, let me be very honest. And one fine morning, this was many years ago, I was in my office and I got a telephone call from a Bhutanese student in Bhutan who had been a JLC student. This has stopped now, but until about 10 or 12 years ago, the government, Royal Government of Bhutan, used to sponsor 8 to 10 students to JLC every year. Reason being that there is no law college in Bhutan. So this boy, if I may say so, he was no longer a boy. I remember him and he still keeps in touch with me. In fact, only yesterday I got an email from him telling me that Bhutan is bad and I hope you are safe and healthy, etc. This boy said that we would like to come down and meet you next week. Can you give us a time? I said, sure. And the first thing which came to my mind was he was with the government. He was the Deputy Attorney General of Bhutan. So really, he had risen to this post. And I was almost sure that he may want me to see some kind of a collaboration agreement or something like that. Next week, they flew down, he and his deputy, and they told me something shocking. They said there is no contract act in Bhutan, and we would like you to draft it. I was shocked and I said, no contract act and you can still do business? They said, yeah, we do it. And they had brought a file with them. And he gave me the file and he said, we had given this job to another lawyer and we are not satisfied with his way of drafting. So can you make corrections in case you don't want to? So I I really was confused, and my initial reaction was not to do it. I discussed this with my family and my friends, and they said, "Well, I think you are very stupid. If you don't accept this, it's an honor." I said, "It may be an honor, but it is also something which where if I make one little mistake, 100 Bhutanese people may have to suffer for it." Ultimately, I was convinced. I went through that draft, and it was drafted in a manner which was more American than Indian. Not that there is anything wrong with the American system of drafting, but it is much more brief. And I said, look, if you want it the way you want it, I may have to change each and every line. Better than that, can we not draft it on the lines of the Indian Contract Act with the additional benefit of your getting the benefit of hundreds of Indian cases and English cases because Indian law is based on English law. So the Deputy Attorney General said, well, that is not in my hands. I will call up the Attorney General and I'll get back to you tomorrow. Next day, he came with a smile on his face and he said, yes, that is possible. So then I said, what we are going to do is to have a contract act of Bhutan based on the Indian Contract Act, but even better than the Indian Contract Act because we have seen certain lacuna and loopholes which we can plug. So then they sat down with me for a few weeks, and then I had to go there and attend some meetings, mostly of businessmen. I said, why do I see so many businessmen? Where are all the lawyers? And I was shocked to hear that in the whole of Bhutan at that time, there were just 2 or 3 lawyers. There was not even a Supreme Court. I saw the building under construction when I was there. I believe it has been constructed today. So therefore, we sat down, and it was a good thing that businessmen were there because they are the people who would be most affected. And we drafted everything. I gave them certain options here and there. But I was a little surprised that although the legislation had been passed by Parliament, it had not come into effect for more than 2, 3 years. And I said, what's the problem? The problem was translating the English Act into the Bhutanese language. And there were so many words that there was no Bhutanese word for that. And therefore, of course, now it's in force. But as I said, the only reason which dissuaded me was the sense of responsibility because I had never done this before and anything could go wrong. But on the sideline, I may mention that Bhutan is a wonderful country, a very beautiful country. The people are so nice. And I'm not trying to promote Bhutan as tourism, but all of you must pay a visit.
Most
So,
definitely. This is very enlightening to see how academia and lawmaking has also gone hand in hand. Um, so one question which perhaps is a well-known fact as well is that the law professors are not remunerated at par with several people who might be in profession. So could you talk about how and why do you continue to be in academia and perhaps even others who continue to be in academia despite such low remuneration in the field?
well, there was a time when I speculated on the possibility of becoming a full-time professor. I mean, I love teaching, and we teach for the love of it, not for the money. But when I was informed that a full-time teacher salary would be 16,000 rupees, I said, this is not enough to support my family. So therefore, you might have noticed that there are few full-time teachers. Of course, now their salaries have gone up like anything. Many of them have a salary of 1 lakh plus a month. But we were part-timers, so there is a lot of satisfaction in teaching, but no money. In my practice, I found that there was money, but not so much of satisfaction. I'm being very honest. I mean, I will just put this to you. Of course, my field was totally different, competition law. But if you were a civil lawyer and you took up the case of one brother who was fighting against another brother for the family money or whatever, and by using all your legal intelligence and acumen and the loopholes in the law, you won the case and you got a fat fee for that. I mean, at the end of the day, where is your satisfaction? What have you done? What is your contribution either to society or to the legal field? So, this is one question which I often ask people, and I'm going to ask Vishwajeet also. After I was in GLC for 35 long years, okay, what do you think was my monthly salary after 35 years? Tell me. Make a guess.
Well, widely considering full-time professors are paid over 1 lakh, I would say about 40 to 50,000 on a part-time basis.
After 35 years.
Uh, perhaps
Okay.
uh,
Then,
con-
then let me shock you by giving you the answer. 800 rupees a month. Now, 800 rupees, even a normal lawyer or a solicitor will make in less than 10 minutes with his client. In fact, I was out of pocket because I was paying my chauffeur more than what I was earning from the law school. So therefore, this kind of a disproportionate way of payment, it's almost the same thing like asking why don't many good lawyers become judges? Well, in about 1 hour, this good lawyer makes what a judge earns in a month. Why should he sacrifice that? We come to college for the love of it and not for the money. And mind you, the amount which we are talking about is fully taxable. Okay, so it's even less than what I have mentioned. Take the current scenario, 6 or 7 of us have been designated as adjunct professors, and we get a little more. But all the other part timers, I'm not talking of the full timers, all the other part timers that you see, they are getting 250 rupees per lecture. Now, this is even less than what you might pay your maid or a cleaner or a servant, and taxable, of course. So, this unfortunate gap is there, and this is something which prevents good teachers from stepping forward and teaching. Also, let me give you one observation which I have made. Academically, a very good student will not necessarily make a good teacher. And I still remember one person who had done his PhD in a particular subject. His thesis was published in the form of a book. We asked him to teach the same subject in law college, and nobody went to his class. He left at the end of the year. So I have often been asked, then what is teaching? Where do you develop the art? And I have always answered that it is only the art, whether it's innate or it's developed, it is the art of making things simple. That's teaching. And therefore, if you have this art, you will be a good teacher.
That's really an eye opener for many, I believe. Just the figures that are taxable are very concerning. Professor, you've highlighted several concerns over the course of this interview. Do you have any proposed mechanism which can actually overtake and better this entire system, not only for the students but also the professors in academia, and create a better society in general, especially for legal education?
I'm sorry, but I don't. And being a student of GLC myself, I have had so many experiences where we had the opportunity, but nobody seems to be interested. And I still remember one particular point of time, could be about 15 years ago, when the President of India, Mrs. Pratibha Patil, was ex-GLC. The Attorney General for India, Mr. Ghulam Vanwati, is from GLC. The state minister, Maharashtra state minister, it was in the Congress days, was Dilip Walse Patil, our student. We even went to his house with certain proposals. The Advocate General, all at the same time, mind you, the Advocate General for Maharashtra was Mr. Kadam, also our student. And I told myself that with this configuration of top people being ex-alumni, GLC, something could be and should be possible. It was only later, after all my tryings, that I realized that I was hitting my head against the wall. The wall did not break, but my head started bleeding. So, mainly because of the fact that this is run by the state government, which really, I'm sorry to say, does not give much priority to legal education that this has happened. And just going back to what we were talking about earlier, as I said, it's not the money, but the satisfaction. And I forgot to mention this, but the satisfaction in my case extends to the happiness of seeing that so many of my students have become High Court and Supreme Court judges. It's really a great pleasure. Let me make one thing very clear. I'm not saying that because I taught them, they became judges. No, they were clever in any case. And they still remember me, they still come to me. And more than 50% of the GLC part-time professors were also my students. And then one day, imagine my shock when I just discovered accidentally that the then current Chief Justice of India was my student. And this happened years back. The gentleman is no more. I was out for lunch and I met an old student whom I recognized. He had his own firm. So we had a small chat. And at the end of the chat, I said, "Are you in touch with your classmates?" So he mentioned 4 or 5 names who were leading lawyers. And then, of course, he says, the boy who always used to sit next to me, Sarosh, he is now the Chief Justice of India. So I said, Sarosh Kapadia, the Chief Justice of India, was next to you in my class. It was an accidental discovery, but this makes you feel happy. This makes you really feel nice.
It's truly inspiring to see that how many generation of not only lawyers but judges and academics, along with several of your own students who teach at GLC at the moment, uh, you've impacted several lives in many ways, and that's truly inspiring. And only one can dream of doing so. So, do you have any vision for legal education in India or law students in general, especially after a post-pandemic world? Do you have any vision for them?
Well, I think the pandemic has done a lot of damage. And I was just reading a few research articles published by American law schools and other schools, where they have found out that because of the lockdown and other restrictions, students are more and more suffering from anxiety, from depression. One study even found that they were suffering from hair loss, dental problems, and I was a little surprised. Skin problems, acne, and other things on the face. And I said, how could this be? And the explanation was very simple: wearing of the mask, especially if you wear it all day, and there are chemicals, and you may be allergic to some of them. So I feel that staying at home, the student has really lost touch with the classroom, with reality, with other friends whom they can only talk on the telephone or see on the video. So things will move again, but I feel that we cannot start at the place we stopped. Maybe we'll have to take a few steps backward and then go forward, because there are certain things which we require to undo before we start doing the new things. But we all hope that this won't last very long and all of us will return to normal life very shortly.
Yes, so that's certainly the hope we have for future. Um, it was truly inspiring to interview and get so many insights on various topics, not only on legal education, but also in terms of legislation drafting, along with how academia in India currently reflects. Jurist is pleased to have you on this forum, and we look forward to having more interactions with you. So thank you so
Thank
much.
you very much. And it has been my pleasure to be with all of you.
Thank you,
All
sir.
of you take care and stay healthy. All the best.
Thank you, sir.